Welcome to the Ontario Catholic School Trustees Association's Professional Development Series for Trustees. In Part 2 of this series, Justice of the Peace Karen Valentine discusses human rights and the law within the context of Catholic education. This hour-long video includes 3 segments for reflection, meditation, a timed moment to pause and journal, and a concluding prayer.
Hello everyone, my name is Karen Valentine, and I will be guiding you through today's lesson on the applicable human rights laws that govern what you do as Catholic School Board trustees. Before we begin, let us first acknowledge that our work as community leaders and trustees takes place on traditional Indigenous territories across the province. We acknowledge that there are 46 treaties and other agreements that cover the territory now called Ontario. In the Durham region where I reside, I respectfully acknowledge that we are on the traditional lands of the Mississaugas of Scugog Island. Please take this time to acknowledge the traditional lands where you are presently. As you do that, let us be thankful to the First Nations, Métis, and Inuit people who have cared for these territories since time immemorial and who continue to contribute to the strength of Ontario and to all communities across the province. Let us be thankful to be able to work and live in these territories. For those of you who are Indigenous, please help us to provide the allyship that your community wants, needs, and expects from us. Thank you. So welcome all of you today to today's session. I'm going to preface my presentation by telling you that I am not a human rights expert. However, I am deeply committed to equity and inclusion. I'm a huge promoter and what I like to believe is a catalyst for change around issues of diversity, understanding, and inclusion, especially as it relates to our systems and institutions. For example, our educational justice and healthcare systems. I know that I sound very high level for now, but I promise you that what we discuss today will make sense, be tangible, and relatable. So I'm going to start off by telling you a little bit about myself. I'm a first-generation Canadian. I was born in Toronto to Jamaican parents. I'm Catholic and the product of Catholic education. I was baptized at St. Joseph's Parish in Leslieville in Toronto. I attended St. Joseph's Elementary School right up the street from the church and St. Patrick's Secondary School, all in the East End of Toronto where I was raised. I have an undergraduate degree in History and African Studies from York University, a law degree from the University of Windsor, and a Master's of Law from Osgoode Hall Law School, York University. I was elected as a Catholic School Board trustee in 2010 to represent the town of Ajax on the Durham Catholic District School Board. Shortly after joining the board, I was elected in 2011 as a regional director on the Board of Trustees for the Ontario Catholic School Trustees Association. At that time, as a Region 9 director, I represented the Durham Catholic District School Board, the Peterborough, Victoria, Northumberland, and Clarington Catholic District School Board, and the Simcoe Muskoka Catholic District School Board. In 2012, I was elected by the other trustees to become the chairperson of our school board and held that post until I had to resign in 2014 to become a Justice of the Peace. I'm a wife and a mother of 2 biological kids and a bonus son. As you can see from today's agenda, I'm going to provide an overview of the human rights laws that govern what is expected of you as you fulfill your role as a Catholic school board trustee. We will start from the very top at the international law level and hone into the Ontario Human Rights Code, where I will focus most of this discussion. Before we break and close this session, I will be quizzing you on what you've learned, and we are going to work through a scenario at the end. This session is dense, but it is that way to reinforce your understanding of the human rights laws that govern what you do as a trustee. I know that we will have a variety of different learners. Some of you have been trustees for many years, decades even, and some of you are quite new to the role. For some of you, this is old information, and some of you might be a novice in this area. This is the beauty of diversity. The hope is that we will learn from each other and that each of you on your board of trustees will celebrate these differences, but also take the best part of your respective experiences, insights, and knowledge to supplement and support each other. So I'm not going to give you a history lesson today. However, for the purpose of what you need to know for your role as a trustee, I have selected post-World War II as our starting point. Because of the devastation and horrors that took place during World War II, including the Holocaust, there was a renewed commitment for an earlier attempt following World War I with the creation of the League of Nations to establish a global bill of human rights that would require every country to recognize the equal rights of every human being, the right to life, liberty, and property, religious freedom, and the use of their own language. As a result, the United Nations was created in 1945. The Universal Declaration of Human Rights was the ambitious project of some of the members of the United Nations, including American delegate Eleanor Roosevelt, who wanted a tangible commitment to peace and equality. However, drafting the Universal Declaration of Human Rights in and of itself seemed next to impossible. Representatives from Asia, Europe, North and South America, and the Middle East, at that time, most of Africa was still under colonial rule, so they were not included, could not see eye to eye on the cultural and political issues. It took nearly 3 years to finally complete the document. Keep in mind the irony of the United States and its own human rights abuses, particularly towards Black Americans. Its history of slavery and its own Jim Crow laws that sustained segregation, discrimination, and prejudice during that time, for me, is problematic. The Cold War between the Soviet Union and the United States was also gaining traction during that time. So it wasn't until December 10th, 1948, that the General Assembly of the United Nations adopted the Declaration. For our purpose, the significance of the Universal Declaration of Human Rights is that the right to education was affirmed as a universal human right for the very first time. Article 25 of the United Declaration of Human Rights affirms that everyone has the right to free elementary education. It makes elementary education compulsory. It included a very important statement that you will see elsewhere in this presentation. Education shall be directed to the full development of the human personality and to the strengthening of respect for human rights and fundamental freedoms. It shall promote understanding, tolerance, and friendship among all nations, racial or religious groups, and shall further the activities of the United Nations for the maintenance of peace. Lastly, it also empowered parents to choose the kind of education that they wanted for their children. However, a couple of the biggest challenges with international human rights laws is that the United Nations had no real power or authority to enforce compliance. In other words, a member country can sign on to the treaty, say that they wanted to do these wonderful things to advance human rights, such as ensure that all children receive a free primary education. But it wasn't until 1966 that we finally had a mechanism to actually enforce or ensure compliance with the convention. So to address this concern, the right to education received some protection in Articles 13 and 14 of the International Covenant on Economic, Social, and Cultural Rights. Each member state, for which Canada is one, had positive and negative obligations imposed upon it as a signatory to these international instruments. Positive obligation being that Canada must provide free compulsory primary education and must ensure equal access to all educational opportunities to primary and higher education. The negative obligation means that Canada must refrain from discriminating based on any of the discriminatory grounds such as sex, race, disability, in providing those educational opportunities, and must also give parents the discretion to decide the type of education their children receives, including religion, public or private education. Article 14 also imposed upon member countries to develop a plan within 2 years to fulfill its mandate towards providing free elementary education to all. Other international conventions and treaties that expanded the right to education over the years included the Convention on the Elimination of All Forms of Discrimination Against Women, 1981, the Convention on the Rights of Children, 1989, the Convention on the Rights of Persons with Disabilities in 2006, and the Declaration on the Rights of Indigenous Peoples, 2007. The difference between the conventions and this declaration is that the declaration in and of itself is not binding on the members, although they had signed on to the acknowledgements of these rights of Indigenous peoples in the declaration. The Constitution Act 1867, formerly known as the British North America Act, came about when the colonies entered into Confederation July 1st, 1867. It established federalism, which really for our purposes meant the distribution of powers between the federal parliament and the provincial legislatures. What's important for us to know is that Section 93 established a constitutional framework for public education in Canada. It authorized provincial legislatures to make laws relating to education. This section also preserved and protected publicly funded Catholic education. The Canadian Charter of Rights and Freedoms, 1982, the provisions that are important for us is the equality provision found at Section 15, which states that every individual is equal before and under the law and has the right to the equal protection and equal benefit of the law without discrimination, and in particular, without discrimination based on race, national or ethnic origin, color, religion, sex, age, or mental or physical disability. Section 29 indicates that nothing in the Charter can derogate or abrogate denominational, separate, or dissentient schools, which basically preserves Catholic education in the country. And lastly, Section 32 of the Canadian Charter of Rights and Freedoms, again, for the benefit of our purposes, tells us who the Charter applies to. So the Charter really applies to Government of Canada, the legislatures of each province or governments of each provinces. It doesn't necessarily deal with some of the issues that we are going to talk about. It does mostly deal with laws. So the point that I'm raising is that although we have the equality rights as expressed in the Charter, most of challenges to laws or practices, etc., mainly come out of the Ontario Human Rights Code. And we're going to talk a little bit more about that. But in terms of who the Charter really applies to, it really applies to state actors. And although presumably or arguably we can say that a school board is a state actor, it's a bit different and nuanced. And so when we talk about human rights protections, et cetera, we're going to find that at the provincial level. And we'll also find it at the provincial level, just given the fact that the Education Act and what we do and the funding or the delegation of power around education is to the province and not within the federal sphere. So this is where we're going to deal with most of our discussion. Most of our discussion is going to be around the Ontario Human Rights Code. And the Ontario Human Rights Code came about on June 15th, 1962. And it was really the amalgamation of various anti-discrimination acts that were brought together into this one new piece of legislation. And it included the Fair Employment Practices Act of 1951, the Female Employees Fair Remuneration Act of 1951, Fair Accommodation Practices Act of 1954. And so really the early code focused primarily on race-related and creed grounds and I would say also gender, okay? The new grounds of protection against discrimination have been added to reflect social changes. So this document is a living document, so to speak. So for example, in its early iterations, it didn't speak to things like sexual orientation or sexual identity and things like that. These are more recent additions in terms of grounds of discrimination, protected grounds under the Ontario Human Rights Code. I will, however, point out that Section 19, subsection 1 of the Ontario Human Rights Code again preserves separate schools that you found enshrined in the Constitution and again affirmed in the Charter. And you're seeing it for the third time in the Ontario Human Rights Code. The Ontario Human Rights Code has 4 key concepts that you should be aware of. Okay, and so when you think about the code, these are the 4 things that should really stand out in terms of its significance. The first being the code has primacy. This means that the code takes precedence over other provincial laws, unless there's a specific exception written into the law. This means that the Education Act that governs what you do as a Board of Trustees will take a backseat to the code. The second key concept is the code is remedial. It is not meant to punish. Instead, one of its purposes is to remove discrimination, prevent it, and provide remedies to help restore people to where they would have been before the discrimination had occurred. The code also tries to foster public awareness through education to help prevent and stop discrimination. Under the code, it does not matter if you didn't intend or mean to discriminate. To understand if discrimination happened, it's the impact on the person or group that matters. The only time intent may be considered is in cases where people face reprisal for upholding human rights under the code. The fourth point is that the code is provincial. It applies to workplaces, housing, services, and other areas that are covered by Ontario laws. The Canadian Human Rights Act, which I'm not going to really talk about, covers workplace and services that are regulated federally, such as banks, Canada Post, airlines, and the federal government. With respect to the Ontario Human Rights Code, in terms of the wording of the legislation, it starts off with a preamble. And the preamble of the code is important because it sets out the philosophy of the code. It states that it is public policy in Ontario that we can all live, work, and receive services with dignity, that we can contribute to society and have equal access to opportunities without discrimination. The preamble refers to the Universal Declaration of Human Rights, which reflects human rights values in Canada and around the world. For this reason, the wording of the Universal Declaration of Human Rights appears in the preamble of the Ontario Human Rights Code. So if you see the second paragraph, it says, whereas it is public policy, right? That's when we're talking about the recognition of the dignity and the worth of every person, equal rights and opportunities without discrimination, creating a climate of understanding and mutual respect for the dignity and worth of every person. And I've highlighted that just so that you can see it's essentially a restatement of the Universal Declaration of Human Rights. After the preamble comes part 1 of the code. This section sets out the right to be free from discrimination in 5 specific areas of our lives called the social areas. They include services, which includes schools, housing or accommodation, contracts, employment, and membership in vocational associations and trade unions. The code does not apply purely to private interpersonal relationships. Of these social areas, which of these social areas do you think your school board may belong to or have a connection with? I would say, from my perspective, housing is the only social area where there's no connection with your school board. Arguably, membership in a union also is, because chances are if there's an issue within the union, it's a kind of an employee or contract or workplace type of a scenario. And the school board, as you know, employs a lot of employees. However, for our purposes today, I really want to focus on student achievement. So I want to stay away from things like HR, et cetera. Of course, sometimes when we use examples, they might come up, but the real nitty gritty for us will be the services, goods, and facilities, which includes schools, hospitals, shops, restaurants, sports, recreational organizations, and facilities. And these are services, goods, and facilities that we access on an almost daily or regular basis. The 7 code prohibited grounds of discrimination are also found in the code: race, ancestry, place of origin, color, ethnic origin, and citizenship. And they're kind of grouped together under race and race-related grounds of discrimination. And then we have things like creed, which also includes religion. And sometimes, depending on a person's creed, they might be lumped or could form part of the race and race-related. So we have disability, sex, sexual orientation, gender identity, gender expression. And we talked about sexual orientation, gender identity, gender expression, not necessarily being in the first iteration of the code, and that these prohibited grounds have expanded over time and may very well expand into the future to include more prohibited grounds as well. The code, as I mentioned, is a living document. Also includes things like marital status, family status. So when we talk about, for example, single-parented homes or same-sex couples, those could fall under marital status or family status. Also age, receipt of public assistance, and records of offenses. But really, most of our issues with the school board with respect to prohibited grounds of discrimination will likely fall within most of these categories. So intersectionality is a relatively new term that has been discussed within the human rights context. It was first raised by a professor in the United States, a law professor from the United States, Ms. Professor Kimberly Crenshaw. Basically, she coined this term to describe what she uses as a metaphor for understanding the ways that multiple forms of inequality or disadvantage sometimes compounds to create obstacles that often are not understood in conventional ways of thinking. And so if you listen to her speak, she does use an example of a Black female prospective employee who brought a discrimination case against a factory challenging its hiring practices. And basically what happens is this Black female, she's listening to this case, and she wasn't happy with the outcome. And it was a Black female who was applying for a job in a factory. They had Black males working on the factory floor, and white women were employed in the administrative or clerical positions. There were no Black females working on the floor, nor were there Black females working in these administrative or clerical positions. And so this potential Black female employee was caught in this kind of a vacuum where the adjudicator didn't see how she could have been discriminated against, since the factory did hire people of different races. However, what the adjudicator failed to see was that she was caught in this vacuum, not necessarily because she was a female only or because she was Black only, but because she was a Black female. And so intersectionality acknowledges that discrimination can happen when a person experiences negative treatments or has a negative impact based on overlapping code grounds. And so you will sometimes from time to time hear about intersectionality or intersecting grounds. So my question for you is, what is discrimination? If we describe discrimination, it can be seen as treating someone unfairly or differently by either denying them a benefit or access to an opportunity, or by excluding them or imposing a unique or special obligation on them that we don't impose on everybody else because of characters such as their race, disability, sex, age, etc. In this context, treating someone differently has a negative or harmful effect. Now, according to discrimination in the human rights context, again, it means treating someone or a group of people differently because of their personal characteristics that are based on any of the 17 grounds of discrimination found in the code. The person or group must also experience a negative impact. So we know that everyone has a fundamental right to free compulsory primary education. We know that this right is to be received equally and without discrimination. Do you think that everyone in your schools are satisfied with your school board and its school's performance in this area? Human rights laws ensures that everyone is treated equally and without discrimination, okay? And so when we talk about human rights laws, you really have to think about discrimination and how we can fix discrimination. So what I'd like you to do is take a look at the definition that you wrote down and then compare it to the definition in the code. Are there similarities? Are there differences? Were you spot on in terms of your understanding of what discrimination means? One of the things that I also want you to consider is when we talk about equity, and we're going to be talking about that a little later on. I want you to consider that sometimes we might have to treat people differently in order to make things equitable or fair. Essentially, the outcome is completely different. So this should not be confused with reverse discrimination, as some people who have benefited from discrimination would like you to believe. You'll recall that the code is concerned with effect and not intent. This means that the negative treatment or impact does not have to be intentional, but it has to be linked to a code-protected ground. This could include an organization's policy or practices that have a negative effect on someone or a group because of a code ground. Again, from an educational perspective, can you think of anything that fits this kind of example? What has your board experienced? It doesn't have to be recent. Now, what have you seen in the news? I'm hoping that at this point, I'm helping you to understand the importance of human rights laws, and in particular, the Ontario Human Rights Code when you are making your decisions as trustees individually or collectively as a board. Next, I'm going to take you through the different forms of discrimination. Discrimination is not always easy to see or identify. There are different types of discrimination under the code. Discrimination can be overt, or it can be subtle or hidden. Direct or overt discrimination can include things like name-calling or harassment, and harassment under the code is engaging in a course of vexatious or annoying or provoking comments or conduct that is known or ought reasonably to be known to be an unwelcomed. Engaging in a course means that what you say or your behavior has happened more than once. Again, it doesn't matter if it's intentional or unintentional, because the ought reasonably to be known, for example, imputes knowledge to some extent. The harassment can range from extreme physical violence to less obvious forms such as ignoring or exclusion. They can be done in a variety of different ways, with or without witnesses, over a period of time, or as an one-off or two-off kind of incidents. It's not always easy for someone to tell the harasser to stop the behavior. Sometimes it's hard for people to speak out because they're afraid of the consequences. For this reason, the code does not require someone to object to the harassment for there to be a violation of the code. Bullying is another form of harassment. It's a tendency of individuals or a group to use persistent, aggressive, or unreasonable behavior against someone else. It can be verbal, it can be nonverbal, psychological, or involve humiliation. Sexual harassment occurs when someone receives unwanted sexual attention, and the person engaging in that behavior knows or should reasonably know that what they're doing is offensive. Moving to subtle or hidden discrimination. An example of subtle or hidden discrimination, for example, is when a landlord screens out rental applications to someone who is on social assistance. This happens without the knowledge of the applicant. There's also a term that's fairly recent about microaggressions, and these are statements, actions, or incidents that are indirect or subtle. So, for example, people who say things like, I don't see color. I have people say that to me all the time, but by not seeing my color, you're not seeing who I am. I know they mean well. However, people who are of color, that's a big part of their identity. Also, when people say things like, I have Black friends, and therefore, without having to say the rest, it implies that by saying they have Black friends, they can't be racist. I get often in my line of work, people asking me about my credentials without necessarily asking my colleagues or other people about their credentials. So it's things like that that over time, or even in the one moment, are seen as microaggressions. Profiling is an example, or it can be an example of both overt or hidden discrimination. For example, a shopper who perhaps might be a young person being followed around in a store or in an expensive store because the perception is they can't afford to shop there. That would be an example of profiling. Oftentimes, however, profiling also is based on someone being subject of greater scrutiny because there's a heightened safety, security, or public protection risk. So, for example, a young person walking in a store and being followed by the salesperson is usually because they think that the young person might steal. Another example of discrimination is constructive or adverse effect discrimination. This is not necessarily between people. This is more the rules, policies, procedures, requirements, eligibility criteria or qualifications that may seem neutral or fair on the surface, but actually lead to discrimination based on code grounds. So I want you to just think about that for a moment. Can you think of a situation where that might have happened? Now, I'm going to talk a little bit about this a little later, but to avoid a finding of constructive discrimination, an organization does have to prove a couple of things, right? So they might have a defense, or they might show that, well, this is really a bona fide or a good faith practice or rule or requirement, etc. Or if somebody wants some sort of accommodation with respect to that policy, rule, etc., that they're not able to do so because of the undue hardship. And we're going to talk a little bit about that later. But what I want you to just understand or take from this is that sometimes constructive or adverse discrimination can be explained, or I should say exempt. Next, I'm going to talk about systemic or institutional discrimination. And this is a pattern of behavior, policies, or practices that are part of an organization and its culture. and it can negatively affect people based on code grounds. Systemic discrimination can exist inside an organization or within sets of organizations. So, for example, when we talk about the educational system or the judicial system, sometimes there are things that are deeply rooted over time that get so entrenched that they become part of the institution or the system. With respect to toxic or poisoned environment, a toxic or poisoned environment could be a form of harassment. An example can be an unwelcome comment or action based on a code grounds. And if it's serious enough, it could really poison the environment. It might be comments or conduct that ridicule or insult a person or a group protected under the code. Unwelcome comments or conducts directed towards other persons may also poison the environment for someone, for example, who may not necessarily be a member of that group, but are offended by the statements nonetheless. A toxic or poisoned environment could be created when code-based harassment is ongoing and widespread in the organization. So, for example, sending offensive emails to everyone in the office or posting an offensive joke or message on a bulletin board based on a code ground is an example of how a poisoned environment can be created. Sometimes a student might believe that they're being picked on, or if they are repeatedly getting into trouble for what they perceive as others doing the same thing. This is something that myself and a handful of other Black children experienced when we were going to elementary school. Didn't happen with all the teachers, but there were a couple of teachers in particular that we were wholeheartedly certain were biased against us based on our race. Of course, at the time, we kept quiet because we were children, mostly, but also because we felt powerless and that we wouldn't be believed. Discrimination by association or perceived discrimination. Someone can experience a negative treatment or impact based on their relationship with a person who identifies with a code ground. And perceived discrimination is a person can experience a negative treatment or impact because they are believed to identify with a code ground, even if they don't necessarily identify with that ground. And lastly, reprisal is just being punished or threatened for speaking up against discrimination or even filing a claim against discrimination. So I just want to provide an overview of the negative impact of discrimination on someone. It could be economic, it could be non-economic. I'm going to just focus more on the non-economic losses for the purposes of our discussion, being a school board or being trustees. It deals with the loss of rights to be free from discrimination, feelings of injury to our dignities, our self-worth, or self-respect, maybe some mental impairment, some depression, lack of confidence in the system or institution, non-engagement. As it relates to students, we might see persistent achievement gaps within a particular code group. Sometimes even academically successful students may not necessarily feel a part of the school community because of their membership in that group. This can also have long-term negative effects in other areas. And again, I mentioned health, well-being, economic self-sufficiency, participation in the society, and wider or longer range could also be its impact not only on the student, but how it affects their families and the larger community, as well as whether or not there's a generational implication as a result of the discrimination. So there is a duty to accommodate. I was mentioning that earlier when I was talking about some of the grounds of discrimination. And so a school board or schools are obligated to take measures to eliminate disadvantages to students, their parents, employees, prospective employees that might result in discrimination from the policies and the practices, et cetera, that result in a negative impact on that protected individual or group. The duty to accommodate recognizes that true equality means respecting people's differences and the need that accommodation should be related to the code protected or prohibited ground. The code allows for defenses to these types of violations. I'm not going to get into that because I really don't want to talk about the legal process. I just want to be able for you to identify some of the high-level approaches to the code and what, for our purposes, is important for us. So for us, exceptions to, let's say, for example, the social group, as well as the groups that are affected, as well as then the effect, there are exceptions if we find those three things. And that is that accommodation can be denied if there was a good faith occupational requirement or good faith justification for it, or if providing accommodation could cause undue hardship to the organization or the institution. So Here's a discrimination equation that I just want you to think about. It includes, for example, the social area that we just talked about. Those are the 5 areas. We talked about where the school board would find itself, one of the protected grounds, right? So 17. And then we talk about the negative outcome. Then we talk about whether or not there is an exception to that. And if there is, it's usually going to be found to be an illegal discrimination. Again, for our purposes, because we're not going to be involved in any of that very high level type of analysis as to whether or not discrimination has occurred, you really should be able to identify the social area, which would be your school board, and whether or not a protected group or person experiences a negative outcome as a result of, let's say, for example, a practice, a policy, a conduct, or any of those other forms of discrimination that I had just outlined for you. Again, I'm not going to spend too much time here. It just talks about where people can go if they want to make a formal complaint. There is a kind of an adjudicative model that deals with these things. I'm not going to get into that, but it's just a human rights tribunal and the types of remedies that are available under the Human Rights Tribunal if there is a finding of a discrimination violation of the code. So this is where we're going to check what we've learned thus far. Okay, so we're going to do 5 true or false questions. First question. The Ontario Human Rights Code was born out of international, national, and provincial laws after World War II. True or false? The answer is true. The Education Act has primacy over the Ontario Human Rights Code. The answer is false. The code has primacy. As I mentioned before, the code takes precedence over other provincial laws unless there is a specific exception written into that law. This means that the Education Act that governs what you do as a board of trustees will take a back seat to the code. Human rights do not apply to everyone. The answer is false. We have the code to make sure that everyone is treated equally and without discrimination. Intention to discriminate is needed to prove discrimination. This is a tricky one because the answer is false. However, I had mentioned that intention is a required element for reprisal. So someone claiming reprisal must be able to show that they are being threatened or punished for objecting to discrimination. And lastly, discrimination can take many forms. The answer, of course, being true. It can be against one person or a group of people. It can be hardly noticeable, or it can be part of the system. It can be direct, it can be indirect, it can be systemic, it can look like reprisal, it can also look like a poisoned environment, harassment, racial profiling. Another question I have for you. Which social group? Stores, schools, community centers, public transportation, hospitals are choices of 5 social areas: services, goods and facilities, housing, accommodation, employment, contracts, vocational associations. That being services, goods, and facilities. Next one, which social areas? We have nurses, teachers, custodians, bus drivers. Again, our choices of 5 social areas: services, goods, and facilities, housing, accommodation, employment, contracts, vocational associations. The answer in this case is employment. The reason why I've done these 2 is it's important to know that as a school board, which is a microcosm of the greater community that we live in, you will find that there are going to be touches in various aspects of what school boards deal with and what you will be dealing with as a trustee. There will be times when you're not just dealing with policies, etc. And notwithstanding the fact that a lot of the day-to-day operational matters are delegated to obviously your director of education, superintendents, principals, etc., there are times when issues at a very high level policy will come before you involving other social areas. Which grounds can this person identify with? A student who is racialized, has a learning disability, and is raised by a single parent. Check all that apply. We have as our options disability, race, place of origin, ethnic origin, color, ancestry, family status, sexual orientation, receipt of public assistance. We know that this person falls under disability, race, family status based on what we're told. But what about what we are not told about this individual? Maybe place of origin, ethnic origin, color, and ancestry may also apply in addition to race. Maybe sexual orientation might apply if the student is gay, but we're not aware. What if the student's family source of income was public assistance? Would that have any bearing on the student? The point is that you're not going to know everything about the students and their families that appear in your schools or that you represent. This also is an example of the intersectionality that we previously discussed. What form of discrimination is this? Your school board hires people from all walks of life, and yet it seems that all of the principals and superintendents are white. Is this a form of overt, subtle, or hidden, systemic or institutional, constructive or adverse effect, or perceived discrimination? And I would say that this is a systemic and institutional form of discrimination. But how do we investigate that? Or do we just stop there? And I guess at this point, what I want you to think about is when we have these systemic or institutional forms of discrimination, they're deeply entrenched. What do we do to rid ourselves of the organization of that type of deeply entrenched discrimination? Because that's really what's being tasked of you as school board trustees. The second part of this presentation is really going to focus now on diversity, equality, and equity, and inclusive education, and what we do or what you do as trustees. There'll be a knowledge check as well. But really now we're going to hone into applying the law that we've learned within the context of what you do as a trustee. So there's some concepts that I want you to first be familiar with, and the first one being diversity. So when we talk about diversity, equality, and equity, diversity is really the presence of a wide range of human qualities and attributes within a group, organization, or society. The dimensions of diversity include, but aren't limited to, ancestry, culture, ethnicity, gender identity, language, physical and intellectual ability, race, religion, sex, sexual orientation, and socioeconomic status. Most of these aspects that make up diversity are also grounds that are covered under the code. In terms of equality, in an organization, its practices, the procedures, the policies that are in place to ensure that all students, their families, teachers, staff, and everyone is treated equally and given the same opportunities regardless of their race, again, sexuality, gender, etc., or anything that can be used to discriminate against them. Equity and inclusive education aims to understand, identify, address, and eliminate the biases and barriers and power dynamics that limit students' prospects for learning, growing, and fully contributing to society. Barriers may be related to those code-protected grounds or other factors, and it is now recognized, again, when we talk about intersectionality, that different factors can be in place at the same time to act as barriers for certain students. So equity and inclusive education policies have been mandated by the provincial government, and they basically include, for example, the Ontario's Education Equity Action Plan of 2017, realizing the promise of diversity, Ontario's Equity and Inclusive Education Strategy of 2009, and the 2017 Ontario Education Equity Action Plan is really a step up from the realizing on the promise of diversity, as well as the PPM 119. And these are really some of the policies and practice guides with respect to how school boards are to implement equity and inclusive education. That includes any kind of anti-racism pedagogy, anti-discrimination pedagogy. All of that is in terms of what should be incorporated in terms of the implementation of policies that each school board must do. With respect to some of the requirements and the regulations, are all set out in these policies. They're good reads to have. The titles are there. I'm going to encourage you to take a look at them. You can Google them, or you can go on the Ministry of Education, Ontario government's website. One thing I will say is that under the strategies, school boards are required or by this point would have developed equity inclusive education policies that include certain accommodations for students and staff, as well as reporting policies within these policies. In addition, 7 regional equity networks were established to support schools and boards in effective implementation of these strategies. So you can see that this is mandated or required by the province of Ontario with respect to Ontario's equity and inclusive education strategies. The 3 core priorities of equity and inclusive education that you should be aware of is simple: increase student achievement, close the gaps in student achievement, and increase public confidence in public education. And those are quite simple. It sounds simple, actually, but it's quite easy to remember. We want all students to do well in school, and we want to close the gaps between students who are doing well and students who aren't doing so well, and figure out whether or not the reasons or potential reasons for why some students are not doing well have to do with, again, what we talked about in terms of those systemic or entrenched institutional forms of discrimination based on those code-protected grounds. We talked about the effects that result from certain identifiable groups being the subject of discrimination, and how that can impact how they view education, their own personal feelings of self-worth, et cetera. And so what we want to do, or the third core priority, is to increase public confidence in the publicly funded education. We want people to believe that the system works for everyone. The 3 goals of equity and inclusive education deals with the shared and committed leadership by ministries, boards, and schools to eliminate discrimination by identifying and removing biases and barriers. Another goal is the equity inclusive education policies and practices to support positive learning environments that are respectful and welcoming to all. And that you can find in the policy program memorandum 119. As well as accountability, transparency with ongoing progress demonstrated through community engagement or communications with the ministry. The purpose of the Education Act is stated in this section, and it's basically that a strong public education system is a foundation of a prosperous, caring, and civil society. The purpose of education is to provide students with an opportunity to realize their potential and develop into highly skilled, knowledgeable, caring citizens who contribute to their society. Also, all partners in the education sector, including the minister, the ministry, and the board, so now this is speaking to you, have a role to play in enhancing student achievement and well-being, closing gaps in student achievement, and maintaining confidence in the province's publicly funded education system. So as you will recall, I talked about the 3 core priorities of the educational system and of equity and inclusive education. There it is. Okay, so you are required or legislated as a school board trustee to play your role in enhancing those 3 things. Let's take a look at the Education Act, okay? And particularly as it relates to your role, we're going to look at section 169.1 of the Education Act. And as you can see, it talks about the promotion of student achievement and well-being, and it talks about creating a positive school climate that is inclusive and accepting of all pupils, okay? And then it identifies, again, those code-protected grounds, okay, under which there could be a potential allegation of discrimination. So your job then is to counteract that by creating a positive school environment that's inclusive. Also required to promote the prevention of bullying, ensure effective stewardship of the board, develop and maintain policies and organizational structures that promote, again, inclusive education, student achievement. You want to encourage pupils to pursue their educational goals. The point is that you really should be acquainted with this particular section of the code, as it does speak to your role. Also, as part of your role is that you have to monitor and evaluate the effectiveness of the policies that you've developed around human rights protections and inclusive and equitable education. And you'll do that by developing a multi-year plan, okay? And The way that I'm speaking sounds like you haven't done it. And of course, we know that school boards now have a multi-year plan. Okay. But you are required to review that multi-year plan every year. And for those trustees who've been around for a long time, I know that you're quite familiar with this task in your role. Another interesting thing that you're required to do is to create surveys to collect data or information from students and staff and their parents and guardians at least once every 2 years with respect to the effectiveness of policies developed by your board to promote those goals around equity and inclusion. In collecting that information, the information should be anonymous, okay? And there should be no identifiers to identify who's providing that information. The hope is so that so that there's no reprisal, I guess, for the information received, but really just to collate that data or information that could be used in an effective and helpful way with respect to improving student outcomes, as well as creating an inclusive school. Again, I've highlighted or bolded some of the important parts of the provision. Okay, so again, every board shall means it's mandatory, include measures respecting the allocations of resources to improve student outcomes that fall below the outcomes. And every board has to bring the plan to the attention of the supporters and employees of the board. So, for example, you might have the parent involvement committee be involved at your particular board, or you might do some outreach to particular groups that are not necessarily engaged, and you want their type of feedback. In any event, you should be familiar with the types of ways that your board is collecting this data. Now, specifically, in terms of not just your role as a board of trustees, but now your specific role as a member of the board of trustees, that's governed by section 218.1 of the Education Act. And it basically says that as a member of a board, you're going to carry out your role and responsibilities in a manner that is consistent with fulfilling your duties of the Act, any regulations or guidelines, etc. You can also attend meetings, of course, and participate in those meetings. But what's important for our purposes is consultations with parents and students and supporters of the boards on the board's multi-year plan, and to also bring concerns of parents, students, and supporters to the attention of the board. In your individual capacity as a trustee, one of your functions is to maintain focus on student achievement and well-being in everything that you're doing. I'm going to ask you what your board is doing at this point. So this is kind of like a checklist in terms of your assessment of the policies and procedures that your board has in place right now. And so at this point, I'm going to trust that since we're well beyond the 3-year time frame that was set in the Ontario's Education Equity Action Plan of 2017, your board has now a well-established anti-discrimination and anti-harassment policy, as well as a multi-year plan. How familiar are you with your board's policies and multi-year plan? Do you know where to access them if you wanted to look them up? Presumably at this point, they'll likely be online, but if not, do you have access to these policies, and can you get easy access to these policies? Because your board must have a plan for preventing, reviewing, and removing barriers, an anti-discrimination and anti-harassment policy, an internal complaints procedure for dealing with these types of issues, an accommodation policy and procedure in place, and education and training program. Similarly, your board's plans should be really focused on removing barriers, and they can do this by setting specific measurable goals for removing barriers, creating clear timelines for achieving these goals, allocating adequate resources towards meeting these goals, and ensuring accountability and responsibility for meeting these goals, and include a way to regularly review and evaluate progress towards the identified needs. Your school board's anti-discrimination and anti-harassment policy should clearly state the organization's commitment to creating and maintaining respect for human rights and fostering equality and inclusion. It should describe the objectives of the policy, such as promoting human rights in the organization, preventing harassment and discrimination, and setting out standards for appropriate behavior. It should set out the activities and persons it applies to and list and explain the grounds protected under the code. It should provide key definitions and concepts. And again, because you're dealing with a school board, we're not just dealing with students. We're dealing with, for example, teachers, principals, superintendents, directors of education, custodians, support staff, occasional teachers. There's so many different people that we encounter on a day-to-day basis. Also, in terms of our policies and procedures, we sit, or you will sit, on a number of different committees, whether it's SAL, audit, whether it's a policy committee, whether it is an accessibility committee. Your policies should also reflect the various committees, or the various committees as subsets of these policies as well. So what can you do as a trustee, or member of the board, in order to keep your eye on the prize with respect to equity and inclusive education? Because it doesn't just end here. Education is continual. You have to continue to educate yourself about Canada's history, particularly with prejudice and discrimination. This will give you the context and the foundation to fight against injustice. You should also be reflective. As you learn more about Canada's history, be prepared to ask yourself how the laws have changed. Are there certain groups that are still experiencing discrimination? Who are these groups? What is your school board and others prepared to do? Or what are they doing about it? And speak up. Challenge yourself in your communities by bringing conversations into your spaces. These are tough conversations to have, but such conversations will seem less difficult the more we have them. And so we have to be really cognizant of the fact that when we are having these conversations, who is the voice, or who are the voices that you're hearing, and who are the voices that are being included, and who's leading these discussions, and who's allowed to lead these discussions, and who do we want to hear from? It's so important to understand that different people are involved in this discussion and in this conversation. Let's have a knowledge test to put into play everything we've discussed thus far. Okay, so the scenario is this. A parent calls you upset that her son has been suspended for the third time in 2 months. She is accusing the vice principal of racism and believes the school environment is poison for her son. The parent is shouting, and you are getting frustrated because the parent is not letting you speak. What do you do? So each of you might take a different approach to this question. It might be based on your years of service as a trustee, it might be based on your own comfort level. But I'd like you to consider that your approach will also be affected by who you are. Maybe it's your professional background, but consider how your race, age, gender, ethnicity, culture, family status, and any other identifier may also affect how you approach this parent. Now, might I suggest to you a course of action that looks like this? Remain calm. Don't interrupt. Listen attentively. Take notes if you have to. Seek direction. Sometimes you may not have the answer in the moment. You may have to refer to established policies or procedures, or speak to your chairperson or the assigned superintendent for that particular issue, or even the director of education. Set expectations when you get a chance to speak, and let the parent know what you can and cannot do. Follow up, take down their contact information. Let the parent know when you intend to respond. And lastly, you might just have to refer or escalate the matter to someone who has the expertise or the ability to deal with the matter. And there might be something in place in terms of a protocol to follow when dealing with these issues. This might lead to a broader discussion at the board level. But in any event, I'm going to ask that you not avoid these types of scenarios. If you haven't, that's great. But if you have, really try to listen to the person who has contacted you, because their frustration has nothing to do with you. It has to do with feeling maybe frustrated or lacking confidence in the system. And so I just implore you to perhaps follow these steps that are outlined when dealing with these kinds of issues, especially when dealing with people who have characteristics or may tell you that they have characteristics of code-protected grounds. Thank you so much for giving me the time to do this presentation for you. I know that we covered a lot. However, it's very important that from time to time we have these types of discussions. Before I close out, I would just like to close with a prayer. In the name of the Father, and the Son, and the Holy Spirit. Dear Lord, we thank you for the opportunity to gather today. Be with us as we leave this meeting. Be with the trustees as they fulfill their role and responsibilities within a framework of equity and inclusion. May you guide their hearts and their minds so that they will remain open to your teachings and what we discussed today. Help us walk with confidence and lead us with your truth as we move forward, praise you, and live our lives in this world. We ask this in Jesus' name. Amen. The Father, and the Son, and the Holy Spirit. Thank you, everyone. And if you ever need to reach out to me, you can do so through the OCSTA. I'll be glad to answer any questions that you might have with respect to anything I've discussed today. Thank you, and take care.